Welcome to week 3 of Laws 12062 Alternative Dispute Resolution. My name is John Milburn. This is for Central Queensland University. We have a number of students online and thank you all for attending in person. Tonight, the designated reading relates to Chapter 2 of Spencer, at least parts of Chapter 2, commencing at page 23 in relation to the question of negotiation. Spencer makes some excellent points in his commentary. He does say that the adversarial system of justice, which is what most lawyers of some experience have been trained in exclusively, does not promote negotiation, and that's probably true. However, as we discussed last week, in civil law, there has been a dramatic rise in ADR in terms of compulsory arrangements. Thanks, John. And in the criminal law, we've also seen some rise in ADR. Now, I didn't touch on this, but you might be interested to hear something about it if you're not practicing in the criminal law jurisdiction. So I'm just talking about the rise of ADR in criminal law. Briefly, there has always been negotiation or plea bargaining, as they like to call it in the United States, but it's never been officially sanctioned. But now it has been officially sanctioned. Following the Moynihan changes in 2010, there is now a formal process which is called case conferencing, which is essentially acknowledging something that we've always done, and that is to try to negotiate, but also to set out a time frame, procedure, and policies associated with this case conferencing. And it's a form of ADR which is driven by the practitioners. It's not so much a form of ADR where the clients, the defendants, become involved, but of course they do drive it in the sense of providing the instructions in relation to it. ADR in criminal law takes a number of different forms. Personally, with prosecutors in the courts that I deal with, we do most of our ADR case conferencing in criminal law via email. That's supplemented, of course, by personal discussions. And those discussions in case conferencing cater for things like a plea bargain in the sense that we will plead guilty to a lesser charge if these facts are changed, etc. Or it might be in terms of a submission that there is no prospect of success on behalf of prosecution and the case should not proceed. Or it might be in terms of some sort of penalty or alternate arrangement. So, for example, last night I was at the police station with a young person who was charged with a serious matter. He had been charged on this some time ago. The matter went to the district court and we resolved that matter through negotiation by having him re-interviewed or interviewed and then either youth justice conference or caution, and in the end he got a caution. So the concept of ADR is going beyond civil disputes. It's now involved in criminal disputes. And if anyone has any questions on that, please let me know as we progress, or use the chat function, or save up your questions until the end. So most jurisdictions, whether that's civil or criminal, now require clients and lawyers to genuinely attempt dispute resolution before proceeding to trial. It is now a fundamental and recognised part of the process. We talked about the parties retaining control of their own dispute, and that's an important aspect, that a dispute is really an important asset. It's a thing that belongs to a person. It's their dispute. And the advantage of ADR is that it stays with that person. It's still their dispute, whereas litigation takes the dispute from the parties and in many ways puts it in the hands of the lawyers, or it puts it in the hands of the court or the tribunal hearing the matter. And why it's important that it stays within the parties? Well, there are a number of reasons: cost saving, less stress, saving in time, saving face, but very importantly, coming up with different ways of resolving the dispute, novel ways left from left field, if I can use that Americanism, is available. But also, it provides the parties with an opportunity to talk about their interests and not necessarily their position. Now, excuse me if I'm covering something that I catered for last week, but a party's interest is not necessarily the same as their position. So a person in a workplace who's aggrieved wants some redress, may be seeking reinstatement, or may be seeking a pay rise or something concrete that the court or the tribunal can order. That's their position. But their interest might be simply to obtain recognition or to obtain more flexibility in the workplace. So what they really want, what is their interest in the proceedings, does not necessarily match exactly their position in the matter and what they're seeking formally. So another advantage of ADR is that we can really talk about interests, and rather than just sticking to parties' positions in relation to it. All right. John, Naomi, is that your point? Criminal cases can also be sent to justice mediation as an alternative to trial. Thank you very much for that point. That's entirely correct. And do you wish to say anything about that?
No, I just wish to bring it to the attention of others that don't work in criminal law, so it's a bit left field for everyone else. But we had it happen last week in the district court, so...
Excellent. Oh, look, it's terrific. In my area, we don't have it available, which is really very annoying. We try to get around that sometimes as well. Another way that we can use ADR in that concept is by entering into undertakings, enforceable undertakings, things of that nature. So that's a very good point, Naomi. So justice mediation conferences are organised, and correct me if I'm wrong, Naomi, but certainly the intention is that they were to be run through the alternate community, the local CJC in any event was to run the justice mediations statewide. We don't have that, but that's what I believe is the case.
Yeah, I'm not too sure how it works. That is all separated from us. So we basically got up in court and said parties want to sort it out between themselves and go to justice mediation, and then it got referred from there. So that was the end of our role as the DPP, so to speak.
Okay, that's good. Yeah, so it's an excellent way of dealing with it. And I think that's quite appropriate in a criminal law context where you're dealing with people that have ongoing relationships. So, if you have, I don't know, a couple of blokes who happen to be brothers that got into a stoush one night, and one of them laid charges for bodily harm, it may be that what that person really wants is an opportunity to sort things out with his brother and get on with it. So that would be in the public interest then, I think, for it to be referred to mediation. Okay, so we've talked about litigation being an asset or something for the parties. In his book, Spencer talks about the fundamentals of negotiation. He adapts the writing of M. Anstey, says that there are 7 attributes to negotiation. And just quickly, negotiation involves more than one party, involves a joint agreement on the outcome, usually requires the movement of the party's position and interest, makes that distinction between position and interest, usually empowers its users by providing self-determination. It's non-interventionary, although we do have very often the role of lawyers and mediators. It's often less expensive than other forms of dispute resolution and allows the parties themselves to control the process and the outcome. In the book, he then talks about the advantages, and those advantages often correspond to the attributes. So, for example, the parties are in the best position, and this is one of the advantages, says Spencer, to assess the impact of any proposed solution. Well, that's attribute number 4. The parties own the process, which we've talked about, and define its terms in any way they choose. Well, that's attribute 7. Parties create their own solution and therefore are more committed to ensuring the agreement settlement works, which is attribute 2. Parties have a chance to get part of what they want, that is, as opposed to an all or nothing situation in the case of litigation. Matters generally settle earlier through negotiation, so sooner is better than later. And finally, if not resolved, it gives the parties at least an opportunity through negotiation to narrow the issues in dispute, and that's attribute number 7 as well. So negotiation should realistically take place either informally or formally through an ADR process other than mere negotiation in almost every dispute, it seems to me. But it is good that ADR is being more widely recognised, and it's becoming mainstream. I think I mentioned last week or the week before that in the 80s, it was only just becoming known to lawyers in particular as a process that could be embarked upon. It was only being regulated for the first time at that stage. So it's all very new, but it's good that it's now commonplace, almost, so to speak. All right, any questions on what we've discussed so far? I'd like to make this as interactive as possible, rather than me just simply reciting things. No questions? All right, in his text, Spencer talks about 4 different models of negotiation. He talks about adversarial, integrative, distributed, and principled negotiation. These are not specifically referred to in practice. In other words, no one will commence a negotiation by announcing that they intend to do so by using, say, integrative negotiation. It doesn't work like that. So it's often intuitive, and the categorizations in the text are probably more theoretical than real, and it's not the case that one must embark on a negotiation by selecting that this will be followed through by principled negotiations. It can change. It can go from adversarial to principled. In the context of an integrative negotiation, there are a whole different ways that these can be done. So it is really a theoretical exercise, in my view, but still a valuable one. And let's talk about what he means by that. I'm sure you've all read the text, so I won't dwell on it too long. But adversarial negotiation, this is the typical familiar win-lose style of negotiation. And Spencer describes it as being sort of lineal fashion. There's one part here, one part down here, and the parties go along that line, as opposed to different forms of negotiation where we can consider these options, which are not necessarily strictly in accordance with the legal dispute, which is that linear fashion. And often it's counter offer and counter offer. And in his book, Spencer talks about the settlement occurring in an area of commonality between the parties' target points and their resistance points. So it's a competitive form of negotiation. It's not creative. And I would think that it provides an advantage to the party with the greatest resources because they can wear the other side down. Integrative negotiation is the next area, which is covered in the commentary. Any questions about that so far? And on page 32, integrative negotiation, I'll just leave you to read that in more detail. But there is some commonality between it and principled negotiations. And it is characterized by its adversarial nature, but distinguished by the use of trade-offs. Distributive negotiation is based on the notion that parties are generally seeking the same goals, and they're negotiating for the same scarce item. So in that sense, it's a zero-sum situation where what is available needs to be distributed between the parties, and in that sense, to my mind, it follows very closely the adversarial approach as well. So in many ways, those first 3 types of mediation models or negotiation models are very similar. And we contrast that really to principled negotiations and the 7 elements of negotiation that are referred to. And if anything, that would be the model of negotiation which is used overwhelmingly the most often, other than perhaps adversarial negotiation. Now, if I could just take a break, I think one student did have a look at the movie 12 Angry Men. Did anyone else have a look at that movie? I'm having a break now. It's worth a look. Nobody's had a look at it yet? We've got a yes.
I had a good look at it when I was doing evidence and proof because it was put up by Anthony Marinak.
Oh, okay. All right. Yes.
It was a fascinating movie. Absolutely fascinating.
Did you watch the original, the 1957 version?
Yes.
With Henry Fonda?
Yes.
Juror Number 8, great movie. And if you Google movies in law, it ranks very highly. And I read one commentary that Juror Number 8 was ranked in the top 50 screen heroes in law of all time. So a great movie. Not a great advertisement for the defence lawyer, I don't think. But anyway. So the question which was posed, and this was one of Lance Rundle's comments, that did Juror Number 8 advance his arguments by using principled negotiation? All right. Oh, so a few people have seen it. That's great. And I thank you for your comments, Naomi, in terms of the justice mediation in that criminal law case. All right, so in principled negotiations, there is the concept of moving from positional-based to interest-based discussions. And when we get to talk more about mediation, it'll become apparent that the agenda item that we want to see is an agenda item which is based around interests. And that's the first element, if you like, of principled negotiations, and that's referred to in the text at page 35. So a position is, what do you want? The interest is, why do you want something? What's motivating you? What's the real reason behind this? And if you can identify the issues in a negotiation or a mediation, of course, you're in a huge advantage in that you can then negotiate around the strict adversarial approach of win-lose and start to think about these other options that might be available. So how do you do that in a principled negotiation? Those of you who've seen the movie, you might have some thoughts about how Juror Number 8 got to a stage where he could identify some interests and he could deal with some issues. Any comments about how that might be done? How do you determine the interests of the parties? I'm going to have a sip of tea while you think about it.
By asking them questions?
Yep. Thanks, Carla. And that's pretty much it, isn't it? What sort of questions would you ask?
Open-ended questions.
Okay. And what does that mean? What's an open-ended question?
Giving them a chance to express themselves and getting their thoughts through and their concerns through to us. And while we do the reframing, I think if we get them to agree of the reframing of their statements, we can get a clear idea of what their motives are or what the real issue is underneath.
Okay. Thank you very much. Yes.
Thank you.
Anybody else wish to elaborate on that answer from Carla? Perhaps I could provide.
Oh, sorry.
Oops, sorry.
Sorry.
Yes, John.
Yeah, I was just going to say, if you want to sort of find out why someone's taking a position, you have to really find out what they're aiming for behind that. There could be something else going on that's very important to them. And if you don't know that, you'll never really why they're sort of sticking to that one position they're in. That's what I was just thinking.
Absolutely. The task of asking open-ended questions is a task which is often provided to barristers or solicitors involved in litigation, where when you call a witness to give evidence, you are required to ask open-ended questions as opposed to closed questions, which is more for cross-examination. So if, for example, in a prosecution matter, the Crown calls upon the complainant to give evidence, the solicitor or barrister or the police officer calling that complainant really is restricted to asking open-ended questions and can't be asking questions that can be answered by a yes or no. That's the simple test. So a closed question is one where a person can answer yes or no. So, for example, if a prosecutor calls a victim in an assault matter and opens with the question, you were struck by the person in the dock on the 10th of March, weren't you? That's an inappropriate question because it's closed. The prosecutor needs to elicit the information by asking an open-ended question, and the complainant then answers by using his or her own words. Contrast that to the same person now being cross-examined by defence counsel or defence solicitor, who is perfectly entitled to ask closed questions. So the question, "This never happened, did it?" is a perfectly normal and appropriate question, even though it's a closed question. So if you need to think about the difference between the two, that might be a context that you can put it in. All right. Options. Option generation is particularly important as well. And juror number 8 was asking a lot of option questions, wasn't he? He was asking for different scenarios. He was asking for the what ifs. He was generating different options that might have been considered by his fellow jurors in that case. And the same thing in negotiation. You're not going to get to the interests, you're not going to think about lateral ways of resolving the dispute until you start to think about the options. And that's a big part of principled negotiations. Brainstorming is a great way to do it as well. And we'll talk about that in mediation. And many of these techniques are used by mediators in practice. So it may be that a mediator gets to a stage of saying, well, look, we need to really work on generating some options. We need to think about how this matter can be resolved and then open it up to the parties to say, let's fly. Are there any options that you can think of? Are there any ideas, no matter how silly they might seem, that can help resolve this issue? And by prompting the parties to do that, you start to get words on paper and you start to think about different ways of resolving it. So options, not solutions, and lots of them. And as Spencer makes the comment about, encourage zany ideas. It might just help. Alternatives. You need to think about what are the best alternatives to a negotiated agreement and think about what you would do if you don't settle the matter there and then during the course of the proceeding. And that can be all sorts of different things, and it might be going to court. That might be the best alternative to negotiating an agreement now, or it might be facing a disciplinary tribunal or doing something else. So it's always good to have in mind, as a negotiator, what is your best alternative to a negotiated agreement, but also what's the other party's best alternative to a negotiated agreement. And if you feel that what is being offered to the other side is better than their best alternative, then you must be getting close to having a resolution of that matter. But you may need to work at it and think about what is the best alternative. Legitimacy. Nobody likes to feel ripped off, so the negotiation may require reference to external sources. The example given by Spencer is, to check the price of a new car, see what people are selling for in other dealerships. But very often the reference to external objective standard means engaging experts to provide an opinion in relation to it. So, for example, in QCAT, from time to time, I'm called upon to make decisions in relation to rent increases in manufactured home parks. And it may be that the owner wants the homeowners, the owner of the park wants the homeowners to pay, let's say, $170 per week for the site rental. The homeowners may say that they are prepared to pay $155 and no more. Well, how do we resolve that? One of the obvious ways is to bring in an expert to say, well, having reviewed other comparable parks, having inspected this park, in my professional opinion, an appropriate site rental is X dollars. So both parties then have the opportunity to consider what has been said by an external source, and it does provide some legitimacy. We see that often in environmental law as well, where reference is made to scientific reports, which carry a lot of weight, of course, in ultimately deciding the matter. But why wait until the trial to get that material? It's important, so why not use it as part of the negotiations on the way through? Fifth point, communication. Many disputes exist because of mistaken or total absence of communication between the parties. And sometimes people do make the mistake in negotiation of simply arguing strongly. Again, he's a bit of a hero of mine now, juror number 8, but he didn't argue strongly at all at any stage. But he didn't force the issue. He didn't force his will on the other jurors. He came in targeted, very understated, and was ultimately, well, you'll have to watch the movie to see what he was. So negotiation is part of compromise, and it's a part of communicating well and clearly and empathetically. Relationship, just be careful about relationships. That's always going to be an issue. It can be a positive, very often it's a negative, and negotiators need to be careful to be empathetic to the other side and listen very carefully. Listening is a very important role of any negotiation, being an active listener, being ready to identify on a word that might just have been said, which can lead to a whole range of discussions. Just one word. So, and you know, look, you look for things like a downplaying of a position. So instead of, at the start, a party might say, I'm claiming this because I am certain that this is the case. But during the course of the discussion, that may be downgraded just in a moment of weakness to I'm pretty certain. And just by adding the word pretty, it shows to the other side, if you're listening carefully enough, that there is some wriggle room. There's a bit of doubt, and there's a bit, and that can then be targeted. That can be a point of negotiation. So you're looking for perhaps the weakness, but you're looking for the opportunities. And that's particularly important in a mediation context. So listen very carefully and listen to single words. And of course, in negotiation, be very careful about writing copious notes. You're not there to act as a stenographer. What you want to do is just pick up on a word or a phrase and jot that down. Often, in a mediation context, I do that without losing eye contact. So you're just writing off to the side. You know it's there, and you can come back to it. All right, so principled negotiations, how do you do it? Arguing positions is easier than arguing interests, so you've got to try and work that round. That means active listening, it means empathy, it means thinking about the best alternatives for both parties to a negotiated agreement, and going from there. All right, so the advice given in Spencer is quite right. The best advice is don't attempt to negotiate based on positions, try to change the rules, and negotiate based on interests. Now, it's all very well in a theoretical sense like this to say that. But of course, the difficulty is actually doing it in a real context. And that's where it would be advantageous if we were perhaps in the one room. We could do some exercises in that regard. But we'll try to build that into the assessment, which I'll come to later. So does anyone have any questions then about principled negotiations, what it is? I've got a few more comments to make, but yes, John?
I just wanted to know what it actually meant, the best alternative to a negotiated settlement and the worst alternative. I can't kind of work out what that means.
Okay, so BATNA and WATNA. So the best alternative to a negotiated agreement. Let's say that you're acting for a party in some litigation, and that party is claiming $100,000 in damages. Their real interest, however, is to ensure that their grandchildren will have enough money in a college account to make sure that they're properly educated. So they're not on the face they're looking for $100,000, but their real interest is to get some money into a college account. But they need to do it quickly because they believe the share market's about to boom and they don't want to miss the bubble. So during the course of negotiations, the best alternative for that party is to continue with the litigation until you get to a certain threshold. There's a certain point where going to court and pursuing the $100,000 is no longer the best alternative to that party. It might be that the threshold point is $25,000 because $25,000 is the figure that they have in mind, which is enough to put into the college accounts to ensure that the grandkids are properly educated. That's their interest. So for them, $25,000 offer may be the threshold where what's being offered is equal to their best alternative to a negotiated settlement. Take it up to 30 and there is no better alternative. So you're in that range. So it's really determining what is for that party the best way to resolve the issue apart from resolving it here and now. I hope that explains it, John.
Yeah, I think that's sort of helping me get along there. Thank you.
It's again, the problem is it's easy to say these things in a theoretical context, but it's much more difficult to do in practice. But you've always got to be thinking about what is the best alternative that my opponent has to the offer that I'm making. Try to put yourself in their shoes. And also, if you're a lawyer representing a party, you're thinking and you're speaking to your client about what is the best alternative for your client to the negotiated settlement, which is on the table now. A bit of reality testing. So as part of it, you as a mediator, you're determining whether in fact what parties think is their best alternative is in reality their best alternative. So it may be, coming back to that case where someone is pursuing $100,000 in damages, they might think, well, that's my best alternative. I'd rather have $100,000. But when you take into account the risk, the cost, the time, the stress, maybe it's not. So there's that aspect as well. All right. Thanks, John. Any questions from anyone else? Any comments? Page 42 of Spencer, he talks about 4 criteria or 4 issues in relation to how to negotiate with principle. There's the objective criteria, separating the people from the problem, positions versus interests, and option generation. So just briefly, the first one, objective criteria. People become stalled in extreme positions. Negotiators should call on any extreme positions and ask them to justify the position. Asking a person who's made a position which is extreme to justify that position has a profound effect. It prevents any points being won on what is false information, and it can embarrass an advocate of an extreme position, and it might prevent future outbursts. Objective criteria are hard to argue against. So the example given is, given that the independent valuations average at $200,000, persuade me why I should settle the dispute for $250 that you are insisting upon constantly or currently. So you phrase it in a way, and it's also a matter of phrasing it in a way as well. So what we're saying there is, if a person's position is dogmatic and they're not prepared to argue, then question their position. How do you arrive at that? What objective criteria do you rely upon to maintain that your position is correct? And I'll come back to that example in terms of valuations, which I mentioned before, and which is mentioned in the book as well. So objective criteria can guide the parties in reaching a resolution. Negotiators should never yield to pressure. Negotiation is about compromise, but it's not about accepting something under pressure or duress. That's a difficult one. In the context of negotiation, we often see one party, particularly if it perceives it's in a very strong position, remain completely inflexible and adopt a take it or leave it approach. And often that's accompanied by the threat or the actual walkout in a mediation context. And that's a tough one to deal with. But there are ways that you try to bring in interests to at least have the tough negotiator think about his or her position. So if it's in the context of a consumer and trader, for example, arguing about the supply of a refund for some goods, if the trader is taking a very tough approach, it may be that you talk about other issues which are in the interest of the trader, such as adverse publicity or the time and cost associated with employees having to go to court. So again, it's a matter of trying to break down that strong position. That is really a commentary in relation to position and interest as well. Now, Spencer talks about separating the people from the problem, and you see that very often. In a mediation context, we try to avoid assigning blame and we try to diffuse situations. So try to give the parties an opportunity to think about the problem and take the personalities out of it as much as you can to the degree that it's appropriate to do that. Positions and interests. Positions are usually the first reaction to a dispute. Interests are what drive the positions. And we've talked about using open-ended questions to deal with that. And the final one is option generation, which we've already talked about, and that's on page 46. So selecting a model for negotiation, I've already made the comment at the start that in my view, in practice, you don't decide that we will use this type of model. That's an internal decision, and it's one that isn't typically announced to the other side. Juror 8 didn't announce what he was doing, but it happens during the course of the negotiation. All right, now that's all I wish to talk to you about in relation to tonight's prescribed material. Before I get into assessment issues, are there any questions? Any comments? There's nothing on the chat line. We'll take that as a no. All right. Now, we talked last week briefly about assignments and assessment. The first assessment task is an online quiz. It's worth 15%. And at this stage, more than likely, it will simply be 15 questions multiple choice, and that will cover issues from week 1 through to week 5 inclusive. It's to be submitted by 5 p.m. on Friday the 15th of August, which is week 6. And at this stage, I'll probably open the quiz on Monday the 11th of August, which is the start of week 6. Now, I need to know if that's going to cause anyone particular grief, but that's what I'm proposing. The return date to students will be Friday the 5th of September, which is week 9. Now, you might think, well, it's going to be extremely easy for me to mark that. I'll mark it probably within about half an hour. So you might ask, why is it going to take me 3 weeks to provide you the results? Well, the answer is it depends on you collectively. I can mark it quickly. I'll get it back to you straight away. But, I'm going to correct myself here. In the quiz situation, if you don't get it back on time, that's it. So I'm going to modify that and I'll get that returned back to you probably within a few days. So you understand from what I'm saying that if you don't return your quiz by 5 p.m. on the due date, then you get 0. Now you're all familiar with the concept of time is of the essence. We'll treat that first quiz as time of the essence. Any questions or comments? Am I being too tough? Good.
So we have from the 11th of August when you open it,
yes,
up until 5 p.m. on the 15th to complete it. Is it just one go, like once you start the quiz and you have to complete it in one sitting?
I believe so, yes.
Okay.
It'll be pretty easy. I think I'll give you a time period. It'll probably be 20 minutes.
Okay.
Does that sound okay?
Yes,
Does that sound fair?
Okay.
Okay, good. All right.
I think so. Thanks, John.
Can I just say this? It'll be pretty easy. It'll be a gentle introduction. So hopefully you'll get 10 or so or more marks for that one. Second one, group discussion, 15%. Now, I noticed that some of you started to answer a question which was left over, as it were, from when Lance took this course last year. And I said, no, the assessment might change. Now, I stand to correct myself. The question, which is the group discussion, which I'll release by the end of this week, is actually going to be very similar to the one that was provided last year. And essentially, it'll be very similar to this. Commencing in week 3, concluding in week 12, select 1 week in which you are to contribute to the topic. The contribution may include discussion of tutorial problem drawing upon additional research which relates to the topic for the chosen week. Students should commence their contribution in the forum of their chosen week with a statement which informs me that their discussion is to be assessed. For the purposes of my assessment, I contribute the following discussion. So that can start this week. If anyone wants to choose negotiation as their contribution to the topic, then by all means do so. Next week, I think, is mediation, followed by arbitration, etc. So you've seen the course outline. So have a look at that and decide one topic that you're particularly interested in, and that will be worth 15%. The assessment will be due Monday the 22nd of September, that's week 12, and I'll return the results to you on that Friday the 26th. Now, that is subject to everyone providing their assessment by the due date. One of the problems that I have at the moment is that even though students are docked, they're penalised 5% per day for late submission, in my view that's not enough, but that's university policy. The only thing that I can do about that is put a close-off date to say I'm not accepting any papers after this date. So if I don't nominate a close-off date, what that means is that people have almost 3 weeks to submit their paper after the due date. And if anyone is in that situation, you'll understand that I can't provide you with my marked assessments during that period of time, which is very frustrating to me and to fellow students. Now, do you all understand what I'm saying there? Do you understand that problem that I've got?
Sorry, just a quick clarification. We need to choose one tutorial problem from the tutorial
Yes.
problems from between week 3 and week 12 and answer it. How do we answer it on the forum, or do we
On the
send
forum.
you on the
Yep.
forum? Okay.
Yeah, on the forum.
Thank you.
Yep. So everyone will be able to see what you're saying. Is that okay? All
Yes,
right.
I just wanted to clarify. Thank you.
Great. Thanks, Carla. And look, some have already started that process. So I think Margaret was one of them. All right. Assessment number 3. This will probably be something about identifying the requirements that parties must undertake before proceeding to litigation in some context. So it's a matter of identifying what or ADR is required to be undertaken in certain circumstances. That will be a written assessment. It will be worth 15%, and it's due on Monday the 1st of September, which is week 9. So 15% week 9, and I'll frame that. Hopefully I'll have these up available within the next week. But you'll be asked to identify ADR requirements prior to litigation and before proceeding to a final hearing. So I'll need to refine that as to whether it's civil or family, whether it's Queensland or Commonwealth or both. But that's essentially what I've got in mind at this stage. Any questions about that? All right. The 4th assessment piece will be, it's nominated to be either a quiz or a group discussion. But what I've got in mind, and something I spoke to you about last week, is a Zoom session, a solo effort, which is the introductory statement as if you were a mediator and how you would approach the parties in a hypothetical situation by outlining what mediation is all about, what are the rules relating to mediation, how is the process to be conducted, why is the process there at all, etc. So a relatively straightforward, pretty simple quiz, but it's in line with the philosophy that I've got, that we've got to introduce some practical aspect to this course, in my view. So again, I don't think anyone was overly concerned about that task, didn't find it too daunting, and it's 15%. That'll be due Monday the 8th of September, which is week 10, and I'll get the results back to you hopefully by the end of week 12. With any luck earlier than that, it depends on how quickly people submit. Any questions, comments? Here's your chance. If you think it's unfair, it's not workable, please let me know.
When will you be putting in writing on your website, please, what you've said about assessment 2, John?
Oh, yes, I will. Yep, all of this will be detailed in full, but I'm just running it by you to make sure that conceptually you understand it and you think it's giving you a chance to tell me whether it's fair or not. So does that answer your question, John?
Yes, thanks, it does. Thank you.
Okay, thank you. All right, so any questions or comments about assessment number 4? Assessment number 5, and again, most of these are not, according to the Moodle, they're not really to be put onto the Moodle site until certain weeks down the track. But I might jump the gun on that a bit, if you don't mind. I'd rather you knew the assessments sooner rather than as nominated in Moodle. But the 5th one, which is 30%, at this stage, I'm thinking of asking you to identify the legislative and regulatory requirements that a person must undertake prior to being formally accredited as a mediator or an alternate dispute resolution provider or in certain contexts. So it's a question which is designed to help you in real terms if, as a result of doing this course, you do wish to practice as an ADR provider. So if you want to be a mediator, I want you to be able to I want you to research what you need to do to be a mediator. If you want to be an arbitrator, I want you to research what you need to be an arbitrator. So that's the general theme of the question that is going through my mind. And again, it's hopefully going to be a question that you can actually use in practice. It'll save you some time down the track if you decide that you want to do ADR. Now, are there any questions about that? Any comments? Does anyone think that's unfair, silly, good, tough, not worth 30%, should be worth more than 30%?
John, what form of assignment will that be? Will it just be written, or will it be a presentation, or?
Oh, gee, I do like this presentation, Margaret, don't I? No, I had in mind it purely a written assignment. Would you like it to be a presentation as well?
No, I'm happy with written. I just wanted, just wanted to know. I think one presentation's enough to start with.
Oh, one so far. No, I had in mind that was a written assignment, and due in week 11, so you've got plenty of time to do it. But I just want you to start thinking about, okay, if I was and of course, embarrassingly, I've not asked whether we do actually have any ADR providers doing the course. Is anyone going to confess that they are in fact already a registered mediator? No? All right. So start thinking about, when you read your book, read your material, think about, okay, what if I was a provider of these services? What would it be like? And what would I need to do in order to become this provider of services? So that's what I've got in mind. Okay, everyone happy with that? And silence is acquiescence. We know that, don't we? That's 30%. The final one, Zoom. Again, sorry, Margaret, in pairs. We discussed this last week. I think I have in mind that you need to, as a pair, write some scenarios and deliver these scenarios intentionally. And I might actually even mix up the pairs so you caught unawares. We'll refine this, but it'll be something like using, in practical terms, the skills that we're talking about, that we're reading about, reframing, taking out the emotion, identifying the issues. So it's only 10%, so I don't want to be making it too onerous, but it'll be something along those lines. So it'll be a Zoom situation, a little bit of play acting, and a little bit of off-the-cuff work to be done on live. Now, anyone, and it's only 10%. So if you find that too daunting, then there's every chance you'll pass the subject, even if you choose not to do it. But I do want this course to be fun. I want it to be such that you felt like you've actually got new skills, and you're able to do new work as a result of doing the course. So that's part of this last one, the Zoom session. Any question with it? Now, we've got a fine with me, says Kitty. That's good. Can we have like some indication? Is everyone okay with that?
Yes, that's fine.
All right, that was good. Was that you, Margaret?
No, it was me.
Oh, Faith. Right. Thank you very much, Faith. All right. Yeah, we've got a sounds good. Everyone's nodding, so we're right. Okay. Yes,
John. Am I coming through clearly? Yes.
Better than you were, John.
Oh, that's good. Well, what I was going to say, it'd be good. I don't know how good I'd be at reframing, but I'd like to actually give it a go. I'd like to sort of, practice it even. It might be an interesting exercise, even though, it might be, you've got to be quick on your feet, I imagine, but it would be a skill I would like to learn.
But that's great. So that's great. Thank you, John. Sorry, I was talking into space then. But no, I'm pleased that you're willing to give that a go. That's great. All right, well, we might be close to wrapping it up. There's no chat comments. Does anyone else have any final comments that they wish to say? Any questions? All right, well, we might end the meeting. Thank you very much. And there'll be further announcements through Moodle. And thanks for your participation and enthusiasm. I really appreciate it. All the best.
Thank you too.
Thank